truth for our people, we able to reach them. So anytime you get accused for a crime and Lord knows you ain't do it, we here to get you through it, exemplifying prudence and glorifying God, making sure you're compensated for other people's doings. Our vision is to be one of the best. We're small enough to focus on your matter throughout the neighborhoods of Dallas, working constantly and making sure your rights are protected. A firm team of lawyers, aggressive, effective, a team that has your back in the courtroom. Two well-spoken black lawyers in the courtroom, investing time and resources when it's evident that you were treated wrong. Now you walking out of Dallas courtroom with a settlement. Corbin and Corbett, the father-daughter legal tag team that has your back in the courtroom. Our purpose is simple: to obtain a favorable outcome for each client and glorify Christ in all we do.
Hello everybody. Attorney Augustus Corbett here with some more legal information that can be very beneficial to you. Yes, today I want to talk about something that is very common, and that is this whole thing of slipping and falling when you're on someone else's property. What can you do? What can we do for you if that were to happen to you? We get a lot of these cases, a lot of people calling us about handling their slip and fall case. Most of them we have to reject because people just make simple mistakes that can really impact their slip and fall case. You see, Texas is a pro-business state. The law here favors corporations. That's why corporations love moving to Texas, because the law favors them. And so there are laws that exist which are very advantageous to corporations and very disadvantageous to folks who are injured on the property of these corporations. I've dealt with many slip and fall cases, and again, if you don't handle it just right after you fall, then you could get your case really just dismissed, actually. Or a lot of lawyers won't even take them, again, because the law really favors corporations. So I want to give you 5 suggestions that I believe can help you if you're involved in a slip and fall case. Now, listen, obviously, we hope that you don't slip and fall. No one should want to slip and fall. The money is not worth it. Sometimes these cases can cause people serious physical injury. We've had torn ligaments, broken bones, broken backs. I mean, these cases can be very serious. When you're walking and all of a sudden your feet goes out from under you, man, that can be pretty serious. And if you're an elderly person, it can be dire serious. So don't take these cases lightly. Slip and fall can be very serious. So that's why I thought it was necessary to come and share with you 5 suggestions that I believe would seriously help you if you're involved in one of these cases. I don't want to see you slip, fall, get injured, have some serious injuries, some serious medical bills, but because you didn't do a few things, lawyers won't take your case. So I'm going to give you 5 suggestions, and if you follow these suggestions, chances are you're going to be able to do okay with your slip and fall case. Now, that said, let's start from the very beginning. Let's start from the very beginning. And that is here. This is what the law requires. The law requires in a slip and fall case that the defendant had actual or constructive knowledge of a dangerous condition on the premise. The defendant had to have known, had to have had actual or constructive knowledge. Now, let me explain. Actual means what the defendant actually knew. He actually knew. The property owner actually knew. They knew that there was a dangerous condition on their premise. Constructive knowledge means that they likely knew or should have known, but they didn't have actual knowledge of it. Okay? So that's a different thing. But either one can carry the day. If there's enough evidence to show that the defendant had actual or constructive knowledge of a dangerous condition on his premise, then the defendant can be held liable for injuries caused by that dangerous condition. And whatever that dangerous condition is, it could be a slippery floor, it could be a nail in the middle of the floor, it could be an area that's higher than another area that causes someone to slip. It can be any number of things. We call this premises liability. And yes, a person is liable when others are on their premises, on their property. But we have to show, once again, that the defendant had actual or constructive knowledge of a dangerous condition on the premise. Now, we usually can show that they had actual or constructive knowledge if the defendant placed the dangerous object on the floor, or he created the dangerous condition, or if it had been there a long time and it's reasonable to think that they would have known that it was there. That's another way. So if they placed it on the floor, if they actually knew, they may not have placed it on the floor, but they knew it was on the floor, or if it had been on the floor a long time, one can assume that they should have known that it was on the floor. So those three ways can help us show that they had actual or constructive knowledge that there was a dangerous condition on their premise. And they negligently failed to fix that issue. They failed to remedy that dangerous condition. And as a result of that, someone failed. Now, when that happens, there's a strong case, okay? There's a strong case. But when we are called about these cases and we don't have that kind of evidence, because we got to prove this. We got to prove that the defendant had actual or constructive knowledge that there was a dangerous condition on their premise and did nothing. So what are 5 things that you can do to put forth the evidence to try to show that the defendant had actual or constructive knowledge? What can you do? Here are 5 suggestions. Number 1, if you see a dangerous condition, if you're in a store and you see a dangerous condition, then inform the store owner. If you're in the store, Walmart, Kroger, wherever you shop, and it doesn't have to be on a store, on anyone else's property. It can be at a neighbor's house. It can be, anywhere where someone else owns that property or manages that property. And there's a dangerous condition, inform the owner or the manager or some employee. Let them know about this dangerous condition. Now, that may not necessarily help you this go around, but it does put them on notice that there's something dangerous on their property. And it may even help you in this circumstance where you inform them about it. Let's say you're in Walmart and you see some water on the floor. You get a manager, you tell them about it, and they promise, okay, we're going to get this up. But they fail to get it up. And you forget all about it, forget what aisle it's on, and 30 minutes later, you're still shopping, and all of a sudden, there you go, right back in that same spot, forgot that the water was there, and you fail. Well, now there's no way that they can say that they didn't have actual or constructive knowledge of that dangerous condition because you told them. So if you see a situation like that, go ahead and let them know. So that's number 1. All right. Number 2, If you actually fall because of a dangerous condition in the store, remain on the floor. Just remain on the floor. Don't get up until someone from the store comes and help you. Or if you're seriously injured, don't get up until an ambulance worker comes and help you up. Okay, let them call EMS and let an EMS worker come and help you up. So just remain on the floor. Okay, don't just pop up. All right, let them come and help you and see you on the floor. Let people congregate around you so that there are witnesses that you fell. There is proof that you fell. And it also shows that you suffered some injury because you were not able to get up. Insurance companies will use whatever they can use against you. So one of the things that the employee may tell the insurance company is that you just got right up. You didn't look to be hurt at all. And then if we come back later and say, no, she had some serious injuries. She fractured a knee. She did this or that. She injured this or that. They may say, no, we got information that she got right up and walked away and there was no issue until she talked to her lawyer. And then all of a sudden she got injuries. So to prevent that from happening, remain on the floor until someone comes to help you up. And if you're seriously hurt, ask them to call EMS and let EMS come and help you up and render whatever medical services are necessary. All right, that's number two. All right, that's number two. Remain on the floor. So number one, inform the owner of the dangerous condition. Go ahead and get a pen and write this down. Go ahead and get a pen and write this down. Inform the owner of the dangerous condition. Number two, remain on the floor. All right, number three, get witness or witnesses contact information. Get witness or witnesses contact information. I can't tell you how many times we've asked someone, were there witnesses? Yes, there were three people standing right there. They saw the whole thing. And then we ask, did you get their information so we can contact them? Oh no, I didn't get their information. Well, how are we going to contact them? How are we going to get in touch with them to find out what they saw? And to hopefully get them to testify on your behalf if necessary. I mean, where are we going to get that from? And a lot of times they'll say, well, the manager came and he took the incident report, and so I thought that he was going to get it. No. The manager is not there to help get evidence for your slip and fall case so that you can sue him. Think about that. That's not going to happen. So you make sure you get witness contact information. This may be, number three, may be the most important one of these suggestions. This may be the most important thing that you can do, is to get contact information of witnesses. I mean, while you're lying on the floor and people congregating around you, don't be embarrassed to say, hey, ma'am, what's your name? Can I get your number? You see what happened to me. These people are probably going to deny this happened. May I please get your number if I need your help? Just ask them, because you're going to need it. Because most likely, again, the manager is not going to do this for you. So you got to do this for yourself. All right, number four is videotape or take a picture of the dangerous condition. Number four, again, is videotape or take a picture or pictures of the dangerous condition. Because if you don't, and you come back later and say it was wet, or this was on the floor, or this caused you to fall, you think the store owner is going to agree with that? Most likely not. Okay? Most likely not. So you got to be able to document. We got to be able to prove, as I told you earlier, we got to prove that the defendant had actual or constructive knowledge of a dangerous condition on his premise, but he then negligently failed to remedy or to fix that dangerous condition. You've got to get that information. You got to be your own best advocate. Okay, you got to think like an investigator, like a lawyer, even while you're down there in pain. Okay, and you just fail hard, and your mind and your emotions are running. You still got to calm down and say, okay, what kind of proof can I get to show that this was their fault and not my fault? We've had store owners to even accuse other shoppers in the store of causing the condition. We've had them to say, yes, the floor was wet, but someone else could have spilled that water on the floor. How do you know that it was us? And how do you know that we knew about it? How do you know that we had actual constructive knowledge? So you got to be thinking like a lawyer even while you're lying there in pain. Okay? All right. Number 5, get a copy of the incident report. Most likely the manager is going to come where you are. If not, request that he or she comes and try to get a copy of the incident report. Now, I'm going to tell you right now that they're going to tell you probably that's not our policy to give a copy of the incident report, but who knows? You may be able to still get it. It may be a different store, different policy, different manager, maybe trying to help you or so. I don't know, but you need to ask for it, and ask for it then and there on the spot. Don't wait. Don't, leave the store and then call back later and try to get it. You probably are not going to get it. In fact, a lot of times they don't even create an incident report because, again, they're hoping this go away. They're hoping that your slip and fall situation does not become a hassle to them. So they may not even document it unless you ask for the incident report, and that will cause them to create one, hopefully, and then you try to get a copy of it. So let's put all 5 of these suggestions back on the screen. Okay, 5 suggestions that can help maximize your compensation after a slip and fall case. And while I got this back on the screen, go ahead and write these 5 things down. Keep them in your wallet or in your purse, whatever the case may be. All right, number 1, inform the owner of the dangerous condition. Number 2, remain on the floor until someone helps you up. Number 3, get witness or witnesses' contact information. Get their contact information. Number 4, record or take pictures of the dangerous condition. In fact, if you can get a recording of some of the witnesses or of the store manager or employees, sometimes the manager will just say, or the employee, whatever the case is, may just admit, yeah, we knew that was there and I forgot to get it up, or I forgot to get somebody to get that up for us. If you can record them saying that, now you have a strong case because you just proved they had actual or constructive knowledge. In that case, it would be not active, but actual. You have proof that they had actual knowledge of the dangerous condition on their premises. If you can, record that. We see how, recording things is a game changer in legal matters because, again, it helps you prove your case. So record and take a picture. Do both, actually. Record and take pictures of the dangerous condition and record everything else. Take pictures of everything else you can. All right. The more proof you have, the better. And finally, get a copy of the incident report. Get a copy of the incident report. Now, again, they may not want to give you a copy of it, and you may, in fact, not get a copy of it, but ask anyway. All right? Ask anyway. So those are the 5 suggestions, 5 simple suggestions that we have for you that can help you potentially maximize your compensation in a slip and fall case. I hope you wrote those down. I hope you keep them on your person. I hope that you don't slip and fall, because again, they can be very serious accidents. Don't take them lightly. But if you do, those are the things you should do to try to prove that the defendant had actual or constructive knowledge of the dangerous condition that caused you to fall on his or her or their premises. All right? Again, I'm Attorney Augustus Corbett, and I hope this helped you.